Hi everyone, I'm Katie Barlow.
And I'm James Ramoser.
Welcome back to Circuit Breaker. Can the federal government impede undocumented pregnant immigrant minors from obtaining an abortion? That's the question at a contentious case before the DC Circuit right now. It's called Azar v. Garza, and we're going to break it down for you today. So James, how did we get here in this case and who's involved?
So this case is about a year old. It all began last year when a 17-year-old undocumented immigrant was caught trying to cross the US-Mexico border. She was taken into federal custody and she was 8 weeks pregnant at the time and she wanted an abortion. So she notified the authorities who said no. The government denied her access to an abortion. The ACLU then brought a lawsuit on her behalf. That case went up to the DC Circuit last October, and in an en banc ruling, the court ruled that she did have a right to obtain an abortion. Notably, then Judge Kavanaugh wrote a fiery dissent in that case, a fiery and now infamous dissent from that ruling.
Then Judge Kavanaugh, now Justice Kavanaugh.
Of course.
And that didn't end the case.
No.
In fact, the ACLU sought to expand the case to a class action on behalf of all pregnant undocumented minors in government custody. And there are hundreds of minors that this could affect. The ACLU is arguing that the federal policy amounts to a blanket ban on abortion for these undocumented minors.
And just in the spring, a district court judge agreed with the ACLU. Judge Chutkan of the DC District Court issued an injunction ordering the government to allow all pregnant, undocumented minors in its custody to obtain access to abortions if they want them. And that's what brings the case up to the DC Circuit now. That injunction is on appeal, and so the DC Circuit now has a second crack at this case.
Oral argument in the case was held on September 26th, and the panel of judges included Judge Srinivasan, Wilkins, and Silberman. All DC Circuit panels are randomly selected, but here at Circuit Breaker, we couldn't help but notice that this panel was comprised entirely of men.
The optics really were striking. And in fact, at the oral argument, you could really hear why this case is such a lightning rod. Of course, it mixes abortion politics with illegal immigration, with a quite extreme Trump administration policy that has liberals very much up in arms. And so here's a clip from the argument in which the lawyer for the ACLU is explaining to the court why the ACLU feels that this policy is so aggressively anti-abortion that it's unconstitutional. Take a listen.
The district court made a finding of fact that this is a policy of not just obstruction of abortion, but also attempted coercion, which is something that we haven't yet spoken about. Before a minor is even blocked from accessing abortion, the government makes her go through a number of hoops to try to push her into carrying her pregnancy to term by forcing her to go to a crisis pregnancy center against her will. All of those crisis pregnancy centers on the government's list of pre-approved counselors are religiously affiliated.
Now, the government's lawyer was equally impassioned. He argued that the constitutional right to abortion doesn't require the federal government to help facilitate that abortion. Take a listen.
Again, we think their government has a strong, legitimate, and a profound interest in the life of the child in the womb, and can pursue that interest through its actions of its own conduct, and that is what is in conflict here in this case. And given that those types of balancing has to be done in each individual case.
So some really strong words on both sides, but despite the heated abortion politics that really define this case, there are some indications from the argument that the judges might not decide the merits, at least not at this time. And that's because all three judges seemed at least somewhat skeptical about some technical issues about how the district court judge defined the class of people who would be affected by this policy.
Yeah, so the district judge applied her injunction to all pregnant undocumented minors. And Judge Wilkins in particular took umbrage with that thinking. and thought perhaps the injunction was too broad because it would undoubtedly apply to undocumented minors that weren't requesting an abortion. So here's an exchange between Judge Wilkins and the ACLU's lawyer on that very point.
So get down to brass tacks. This isn't poker. I don't need to hide my hand. I have some serious problems identifying a policy that you are challenging in this lawsuit that inflicts an injury upon a minor who neither expresses an interest in or a desire to terminate her pregnancy. And so I need you to help me with that.
The class must protect the ability of all pregnant minors to make their own decisions free from government obstruction and interference. And that should be...
As an abstract matter, I understand that, but we're not suing based on abstract matters. We're suing to challenge policies that violate a statute or the Constitution.
Now, I think it's likely that Judge Wilkins is a swing vote here.
It does seem like he could play that role, and that's because you have Judge Silberman on one side, who's one of the court's most conservative judges. He was quite hostile to the ACLU's position throughout the argument. And then you have Judge Srinivasan, who's a more liberal-leaning judge, who, at least on the substantive question of the abortion rights issues in the case, seemed quite sympathetic to the ACLU. And then you have Wilkins, who himself is a liberal too, like Srinivasan, but like you say, Katie, he several times expressed skepticism about these technical issues, about the scope of the injunction, and he suggested that the best course right now might be to kick the case back down to the lower court so that the lower court judge can sort of sort out these issues about the scope and the extent of the class and the class certification.
Yep, I think we very well may see Wilkins put pen to paper on an opinion that says exactly that.
Yeah, I would not be surprised if we saw something like that. And regardless of what the opinion says, this is a very fast-moving and very important case. Yeah. We certainly haven't heard the last of it at the DC Circuit, and we'll be sure to keep you updated on everything going on in Azar v. Garza.
Thanks for watching, everyone.